Quick update at Birdwitch. The city of Miami Gardens has shut us down, and our lawyers say it's illegal and unconstitutional. And yes, we may have to sue. We did everything right. We got our necessary state licenses, health and fire safety inspections, and signed a valid lease with the landlord to be on their private property in a business district. But to our surprise, just a few days after our grand opening, a code enforcer came and yelled at our employees, telling them they couldn't be there. A couple of days later, our landlord received a violation for unauthorized use general. Now, we picked Florida specifically because of a state law passed in 2020. Florida Statute 509.102 explicitly says that cities may not prohibit mobile food dispensing vehicles from operating within the entirety of the jurisdiction. State law supersedes city law. We pointed this out to the city attorney and the code enforcer. After getting nowhere, we met with the director of code enforcement. This is where things got interesting. We explained that the city was violating state law, and the director told us to refer to the city's code, which they believe allows them to ban us, despite it clearly saying nothing of the sort. But as our lawyers have made clear to the city, this is a classic case of legal economic protectionism. The Florida Supreme Court has repeatedly held that local governments are not allowed to discriminate between favored and disfavored businesses. What the city is doing is illegal and likely unconstitutional. From there, the director argued that anything not explicitly mentioned in the city's code is prohibited, a ridiculous catch-all argument that our lawyers say cities will occasionally use to target anything a city doesn't like. But even if that were illegal, the state law explicitly allows us to be there. And here's the big reveal. When we said that state law supersedes the city, the director of code enforcement looked at us and said, "That is what we will be fighting." That's a smoking gun. The city openly admitted they intend to violate state law and that they're prepared to waste taxpayer money fighting a lawsuit they have no way of winning. That's when the director revealed their legal trap, saying the city doesn't have an issue with us, they have an issue with the landowner. That's why the violation was sent to them. They claim we have no legal standing to sue. By definition, a mobile business rarely owns the land they're on. It's a systematic trap to deny an entire class of businesses their rights. So the city's strategy is to wait things out, knowing that we're losing money every day. And they hope we'll be like all the other food trucks that they bullied in the past and move on without fighting in court. We've now partnered with the Institute of Justice, a national civil liberties law firm, who sent a letter to the city demanding they become compliant with state law. We spoke before city council, and the mayor said he'll speak with the city manager. We just want to sell the best chicken sandwich anyone has ever had. In the short time that we've been open, the community gave us a perfect 5-star rating, and we were invited to half a dozen events. The property owner wants us there. The only issue is a small group of individuals who appear to be openly defiant towards state law to discriminate against food truck owners. Since our story was featured on the radio, we've already heard from other food trucks and property owners who have been targeted. If you know someone who's had a similar experience, not just in Miami Gardens, or if you'd like to find ways to help, send us a message. Thank you so much. More updates coming soon.